Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, everyone. Welcome to another edition here of the Empowering Plans Podcast, or now on video. I'm Brady Bizarro. I'm the Vice President of Consulting here in PGC at FIA, and Brian O'Hara is joining me today to do this podcast. Say hello, Brian.
Hello, Brian.
Perfect. We're off to a great start so far. So today, we have an interesting case today to talk about and probably go a little more in depth and provide some more legalese than we normally do, but there's a good reason for it because the Supreme Court has been relatively busy so far this spring. Typically, they release a flurry of cases in June, right at the end of their term, kind of rushing to get things done. But we've got some nuggets that have come out from them in the interim, things that relate to surprisingly employee benefit plans, because a lot of the other activity they've been involved in has to do with arguably other more important things like, executive authority and more actions related to the president. But in our case, we did get some things that are worth discussing. And so it's actually a case that it's Cunningham versus Cornell University. And so this case, they decided April 17th, and kind of want to go over the background because it's got some interesting implications for plan fiduciaries. And I think it's likely to lead to a waterfall of lawsuits, probably against plan sponsors. And we'll talk about why that is. So just to give some background here, as is often the case when we talk about litigation about fiduciary duties, this involves the retirement plan world and not the health benefit plan world. But because both of these are governed by ERISA, both types of plans, there's implications for our industry as well. Very, very clear implications. So in this case here, you had a group of current and former Cornell University employees who are participating in two of the university's ERISA retirement plans. Very normal, right? Nothing wrong with that so far. But they alleged in their complaint back in 2016, so a long time ago now, that there was a breach of fiduciary duty committed by Cornell and the officials involved in overseeing the plan because they were engaging in prohibited transactions under ERISA. And they looked particularly at how certain service providers of the plan were selected, how the plan was structured, and the fees that were being charged to them for their investment options, and allegations that they allegedly failed to monitor and control the costs to plan members and participants. And so they focused on two record keepers that they thought were charging excessive, and in some cases, duplicative fees. So again, just a little more detail than perhaps we need to go into, but the takeaway here is that these two record keepers were allegedly tied in some way to investment products that limited the members' choices and locked them into high fee arrangements that over time were eroding the retirement accounts of the members on the university here. So that provided the sort of the basis for the lawsuit, and they framed the lawsuit as a prohibited transaction claim under ERISA. So ERISA section 406A 1C says a fiduciary shall not cause a plan to engage in transactions that constitute the furnishing of goods or services between the plan and a party in interest. Now, there are some exemptions to this where it's allowed, but this comes down to whether or not the fees being charged in this case were justified or not. So originally what happened in this case? So this case ended up in the Second Circuit. And that court ruled the plaintiffs had to plead around the exemption, or in other words, they had to allege that the services being provided to the plan were unnecessary or overpriced just to move forward with the case. So this isn't even a case where the merits were being discussed yet, right? This is just kind of like a procedural threshold question. The Supreme Court rejected that argument and gave an opinion saying that the plaintiffs in this case only needed to plausibly allege that a prohibited transaction occurred. And then when they do so in the complaint, it's the fiduciary's burden to raise an affirmative defense, such as, for example, the services were necessary for the administration of the plan and the fees were, in fact, reasonable, and prove that later in litigation. So you basically had a circuit split right, where different circuits came down with different interpretations and rulings in cases like this. Some were allowing the court, the case to go forward by pleading around the exemption, some were not. And so this is very common for the Supreme Court to get involved and step in and resolve the circuit split. And that's why this case eventually, I think, made it through to the Supreme Court, because as you listeners and viewers know, the Supreme Court gets to decide which cases it takes, right? Only has so many hours in the day, even for the justices of the Supreme Court. But this is one that was very important for them to weigh in on. So you might ask, what are affirmative defenses? Why were they important in this context, and why does it matter that the Supreme Court basically said that this shifts the burden to the fiduciary to raise affirmative defenses? So essentially, it's an important concept in litigation. So when you're raising a set of facts or arguments that, if you prove them, negates liability, even if the plaintiff's allegations are true, those are affirmative defenses. So it's not something a plaintiff has to refute in their initial complaint. So in this case, again, why it's so important is that the plaintiffs didn't have to overcome the affirmative defenses that Cornell could raise in the complaint. All they had to do was allege that a prohibited transaction or unreasonable fee was paid. That then the court is now allowing that case to proceed. So, Brian, I want your take on this, both what you think of the case, generally speaking, and why you think it's important for health plans, how this kind of transitions over to our world.
Sure. Thanks, Brady. I mean, so, like you've mentioned, this is kind of a nuanced procedural issue. But what this is going to kind of open up is it's going to make it a lot easier for plaintiffs to survive a motion to dismiss, which means that a lot more cases are going to proceed into discovery, which can be very costly. And then that leads, plans to kind of make that determination of, well, is it more cost effective to just settle than to proceed with expensive discovery and things like that. So this procedural issue is very important. Now, the case, as you mentioned, revolves around a retirement plan, but as we know, ERISA's prohibited transaction rules apply broadly to all ERISA covered plans, including group health plans. And group health plans engage a number of entities that could be considered parties in interest. This includes third-party administrators, pharmacy benefit managers, brokers, consultants, etc. So health plan fiduciaries should really take even greater care than before with respect to these parties and interests. This includes, documenting the necessity of services procured, evaluating the reasonableness of fees, especially in light of the Consolidated Appropriations Act of 2021, which expanded transparency obligations for group health plans. Now, it's important to note, Brady, you kind of touched on this, but it's important to note that paying reasonable fees to a party in interest is not prohibited. Reasonable fees are not the problem. The problem is unjustified fees. There are services out there that help health plans comply with complex regulations, such as, for example, the No Surprises Act, which I work on regularly, and that includes the Independent Dispute Resolution or IDR process. So paying for these types of services are not only permitted, but they're also critical for avoiding certain other costs, like, for example, avoiding compliance penalties, managing high cost out-of-network claims, and in general, reducing overall plan spend through the claims negotiation or cost containment. These are really exactly the type of value-adding services that ERISA affirmatively permits under the 408(b)(2) exemption, so long as the fees are reasonable in light of the services provided. So if your company charges for things like IDR support, out-of-network claim negotiation, analytics, or compliance assistance for complex laws like the No Surprises Act, that's fine. What matters is ensuring transparent pricing, having a documented fiduciary review process by the plan sponsor, and having a clear justification for the value and necessity of those services. So, in short, the Cunningham decision doesn't outlaw paying for these services, but it does reinforce the fiduciary obligation to evaluate them carefully.
Yeah. And Brian, it's interesting because in our industry, I've been at FIA now for 9 years, and I've seen this even just in my time here. The number of vendors that have popped up, each charging their own fees, has really increased dramatically here. So if you just think about the number of things that a plan would typically pay, number of vendors a plan typically pays. I mean, you've got obviously TPA fees for claim processing, you've got stop loss premiums and fees, you've got PBM fees, you got network access fees, you might have fees associated with medical management and utilization review, things like case management or prior authorization services. If you're engaging companies like, say, FIA to provide consulting, right, under the ICE service, for example, or mental health parity reporting, there's fees associated with that, claim negotiation fees. You might be paying data and technology analytic fees to different vendors who are helping you integrate your platforms. So there's a lot of fees that there's inflation of fees over time. But to Brian's point, right, the issue isn't the fees themselves. It's when they're unreasonable. And you might be asking, when do I know that they've become unreasonable? Well, one of the ways, and this is why, by the way, the Consolidated Appropriations Act is requiring so much data collection, because you can create a benchmark, an industry standard for what fees should be, right? So if you're comparing your fees to the industry benchmark and you're paying way more, there's a problem with your fees, right? Or if the fees aren't transparently disclosed at all, or if they're duplicative. If you have 3 vendors that are essentially doing the same thing, right, that could be a case where you should be worried about facing an allegation of excessive fees. So also, ultimately, right, maybe most importantly, if the fees are misaligned with the actual value, that's a problem, because if you're not actually able to show savings for the plan, then you're paying really high fees. There's an issue there. So, I mean, what I would be doing, right, is expecting more litigation here, because notwithstanding everything we just said, ultimately, what this case was about was allowing plaintiffs to proceed past a motion to dismiss with a simple allegation that excessive fees are being paid, or that a party to whom fees are paid is a conflict of interest or a prohibited transaction, a party that would result in a prohibited transaction occurring. So it just means that you need to have your documentation ready to go and be able to fight off a case like this, a challenge like this, by a plan member. Or in some cases, it's likely to become a class action case against the plan fiduciary. So kind of, I guess I would call that bad news in some way, because litigation is expensive, even if you're correct, right? Having to defend yourself is expensive. But one of the things, we take pride in at FIA is our fees are all disclosed. We think we add value in all of our services. And so certainly if you have questions for us about our certain services, we can answer them. But also if you have questions about, whether your plan or plans that you administer are paying fees that are excessive, or how to help create some line of defense for that, we can help you provide answers to those questions that you might or you should be asking internally as well. So, Brian, any kind of last thoughts on where we're going from here, or on the case generally?
So I would note that the Supreme Court did kind of understand and address the fact that this might create more litigation, and they did kind of give some indications of what plans can do kind of to help mitigate this, including a standard showing or forcing plaintiffs to show some actual harm. There's also, rules of professional conduct and rules of civil procedure that can be raised in terms of bringing, certain attorneys bringing frivolous lawsuits. So there are other ways that this can be addressed that the court made sure to notice. But like you said, this ruling can bring an increased number of lawsuits, especially with savvy lawyers that, those lawyers, they're just, if they can bring a case, they'll if they can find justification, they'll do it. So, it definitely is important to, make sure that you review your fees and your contracts and making sure that these are reasonable.
Yeah, absolutely. And what the author of the opinion here, Justice Sotomayor, said, she acknowledged, you pointed out, acknowledged the risks here of more litigation, but she described that as a feature, not a bug, of ERISA, that fiduciaries have to be able to justify transactions that otherwise would be prohibited. And that actually she wrote, I'm quoting her now, while these concerns may be valid, they do not permit courts to rewrite the statute. And so kind of like you have to kind of deal with it. They're weighing a balance here, of course, because if you think about the opposite of this, right? If these cases were just dismissed at the introductory level, and plaintiffs don't have all the information to know for sure whether the fees are justified or not, you have to get to that next phase, that discovery phase in the lawsuit, to actually get this information out there and adjudicate it. So they balanced things out and ultimately came down where they did. But just another example of where, we pay close attention to, ERISA employee benefits. Generally speaking, we're not just limiting our focus to health plans, because if we did that, we'd miss out on cases like this, which have a tremendous impact on our industry, and will continue to do so going forward. So as with all other things going on right now, and there's quite a few things happening in DC and in the courts and everywhere else, we'll keep monitoring developments and bringing you the information and some best practices for how you can limit your costs and also make sure you're doing best by your clients. So I think that's a good wrap up for now. So on behalf of myself, Brian O'Hara, and our producer, Pat "The Man" Santos, I want to thank you all for tuning in, listening, and watching to Empowering Plans. And we'll see you next time.
Go
Take care.
Celtics.
Indeed.